Okay, good evening, everybody, and welcome to the Wednesday evening seminar. Tonight we are joined by Richard Silver, Senior Partner of Silver Law, for the latest in his Construction Essentials seminar. And tonight he's going to be looking at payment and smash and grab. As always, Richard is delighted to answer questions from you. So if you could pop your questions into the Q&A or chat facility on the bottom toolbar. Alternatively, if there is anything that raises tonight that you don't want to raise in an open forum, his email details are on the screen there and will be in the at the end screen as well. You can always contact him directly. Without any further ado, Richard, over to you.
Thank you, Julie. Good evening, all. I hope you're enjoying the fine weather. As Julie has indicated, I'm going to deal with smash and grabs adjudications. As many of you will know, hopefully, apart from being a representative of parties in adjudication, I'm also a panel adjudicator on such panels as the RICS and the CIArb. On average, I am appointed as an adjudicator probably around 20, maybe 25 appointments a year. And of those, I would say at least between 10 and 20% of them are smash and grab adjudications. So it shows how much smash and grab is being used on projects by contractors or subcontractors in seeking to obtain payment. So what is a smash and grab claim? I imagine the majority of you will only be too aware and will have read or heard of them. But just in case, I will go through what is the background to smash and grab. Now, you will all hopefully be aware that following the Construction Act, there is a requirement within all construction contracts, and that is contracts on construction projects, save for works done to people's residences. There is an obligation to have within the contract a payment mechanism. This must set out effectively what the contractor is to be paid and when. So what the contract must have is a valuation date. Now, you can put in that the valuation date, for example, shall be the last Thursday in every month. It shall be the same date in every month. It shall be every third month. It shall be at stages of the works. You need to say something in the contract that sets down a valuation date. If you fail to do so, the scheme for construction contracts fills that gap. So for example, if you've got a valuation, no valuation date stated at all, under the scheme, there will be a valuation undertaken every 28 days following commencement of the works. What we then have to have in the contract is what is called a due date. Now, to try and best explain that, if one goes back many, many moons, you will remember that an architect issued a certificate. But when the architect issued that certificate, you weren't entitled to be paid that day. There was a certain amount of days following the issue of the certificate. What we now have is a due date, which is the same. It is a date which is fixed from which certain things occur. So it may be that we have a valuation date on the 1st of the month, and the due date is 7 days thereafter. And that's what's mainly provided in most of the JCT forms. We then have it following the due date, a payment notice. Now the contract can provide that either the payment notice is to be issued by the contractor or the employer, but under most forms, standard forms, as you would imagine, it provides that the employer or their representative has to issue that payment notice. And quite often it is something like 5 days after the due date and not beyond. And within that payment notice, what they must do is to set down the amount due and the way you calculate it. And what that effectively involves is 2 parts. The first part is you must show how the gross value is reached. So for example, you would say preliminaries 40,000, substructure 50,000, superstructure 80,000, variations 33,000, materials on site 10,000. And that, let's just say, comes to £1 million. So that's how you've worked out the gross amount. Now you need to work out the net amount. So you'd say, therefore, that it is £1 million less retention, less previous payments equals a payment due of £100,000. And you have to have both those elements within your payment notice. If you don't, it is not compliant. If you issue it late, it is non-compliant. We nearly complied. You either have or you haven't. Now, where the contract provides for the contractor, or as the case may be, the subcontractor, to issue an application, and the employer fails to issue that payment notice, the amount applied for becomes the notified sum. It becomes the amount payable to the contractor. Now, let's just say that the contractor applies for more than they're entitled. Dare I say it, that's the normal course of events. So the contractor has applied for a loss and expense claim with very little backup and support, but has asked for £1 million. If you don't issue a payment notice, that amount applied for becomes the notified sum. Now, we have a second notice, and that is generally required a set amount of days before the final date for payment, which is another date that must be stated in the contract. But the pay less notice is in the exact same form as the payment notice. It should set down the amount due on the due date and can actually reduce the amount previously stated within a payment notice, or it can in effect take the place of the payment notice where no payment notice has been issued. Now, as with the payment notice, the pay less notice must set down the gross amount due and ultimately the net amount due. So it could be the amount as stated in the previous notice, payment notice of £100,000, but we now want to deduct from that £50,000 worth of liquidated damages, so the net sum due is £50,000. Alternatively, if there's been no payment notice issued, the pay less notice can simply start from first principles, give the full amounts of due by saying it comes to £1 million as before, less previous payments, less amounts being withheld, and comes up with the end figure. Now, because both the payment notice and pay less notice must be in the same form, it must set down the amount due and how it's been calculated. If you issue a payment notice late, it may well nevertheless constitute a compliant pay less notice if it's issued in due time. So it isn't relevant whether it says on the top payment notice or pay less notice. It is whether or not it requires the relevant information. And the important point is even if you think no monies are due, you still have to issue a payment notice, or if you fail to issue a payment notice, a pay less notice, because if you don't, the contractor is entitled to the amount that has been applied for. So what is a smash and grab? Well, what has basically happened is the contractor has submitted an application. It is compliant in that it is issued on the right time, and it is issued in the correct format. The employer, for whatever reason, has either forgotten or chosen not to issue a payment notice, and as a consequence, the application becomes the amount due, the notified sum. The employer has then failed to issue a pay less notice as well, and then the final date for payment has elapsed, and therefore the contractor is entitled to the amount he applied for. Whether it is right or wrong is irrelevant. Provided it was a compliant application for payment, it becomes the amount payable following the final date for payment. Now, the case that dealt with this was ISG versus CIVIC. We've got all the particular details there. And what basically happened is exactly what I said before. The contractor submitted an application, the employer failed to issue a payment notice or a pay less notice. The contractor went for a smash and grab and was awarded the full amount of applied for. The employer then sought to go to adjudication to work out what was the proper value due. In other words, they said, well, yes, under the contract, it may well be the case that we should have paid the application, but the application, to put it bluntly, is rubbish. These cowboy builders, they're asking for amounts that are wrong, that they're not due, and it's not justified. And we should only be paying for the value of the works properly undertaken. And unfortunately, the court decided otherwise. The court said very simply, you have had every opportunity to issue a payment notice, and you've had every opportunity to issue a pay less notice, but have chosen not to. And therefore, you have to pay the amount applied for. Moreover, you cannot subsequently go to adjudication to dispute the amount found due. In other words, you cannot start a second adjudication on the same application. That seemed to be a major concern, and it created a whole lot of press and ultimately a large amount of adjudications. Now, the second case is a very interesting case, and it's one called Pace and Springle versus Harding. And it involved me. What actually happened was I received a call from Pace and Springle, and they advised me that they had been involved in an adjudication, a smash and grab, and had lost. And the situation was that they were the employer. They had certain works undertaken by a contractor, but to say the very least, they and the contractor had fallen out. Now, Pace and Springle had obtained certain advice, but it would appear that either that advice was not very good or they didn't follow it. But ultimately, because they failed to make payments and other failures, the contractor had terminated under the contract, had issued the relevant applications for termination following termination. They hadn't responded, and therefore he went off to adjudication and sought payment of the amount applied for and won. Now, Pace and Springle, to say the very least, were disappointed, and they asked me what could they do. Now, whilst at that time it was not quite clear, I suggested that they go on the proper value of the works undertaken following termination, to which they agreed, and we commenced an adjudication. It goes on. Harding then went to court to have those proceedings stayed. What they said in simple terms is that Pace and Springle ought not to have a right to go to adjudication when they themselves had yet to comply with a decision in a previous adjudication. And the courts agreed. So they stayed the adjudication pending Pace and Springle paying Harding the amount that had been decided due in the first adjudication. Having paid the amount in the first adjudication, we then recommence the adjudication. Pace and a decision was given in favour of Pace and Springle, and the courts prior to that decision had agreed that Pace and Springle could go to adjudication on the proper value of the works undertaken. But what then happened was, unbeknown to many, the adjudicator in the second adjudication had spoken to Pace and Springle on the phone, or his secretary had spoken on the phone prior to the second adjudication having commenced. And because of those discussions, which the contractor had found out, it was held that the adjudicator had breached natural justice. So his decision was unenforceable. So we went up for another adjudication. And in that adjudication, again, it was decided that amounts were due to Pace and Springle, but Harding disputed that the decision was enforceable, and we all went off a court again. But this time, the court enforced the decision, and Harding was required to pay money back to Pace and Springle. Now, the important point from this case with regards to smash and grabs is it was held that because this was a payment following termination, The previous case I referred to, ISG, was not on all fours. In this situation, because it was following termination, the judge reached the conclusion that you can go on the proper value of the works undertaken, notwithstanding the failure to issue notices. But you could only do it if you first paid the amount due following the smash and grab. What then happened was a further case. This one is Gallifoot versus Asturia. And the problem before the courts was the two different views. The first one from ISG, the second from Pace and Springle, and which one should they follow? And it was decided that Harding and Pace turned on its particular facts in that it followed termination. What it was decided is that with regards to general interim payments, you could not go on the proper value of the works undertaken. And then we finally have Grove Developments versus S&T. And dare I say it, common sense finally prevailed. And what happened in Grove is that it was decided that provided you paid the amount based upon a smash and grab, you could thereafter go on the merits of the application. So let me just explain clearly what that means. Let's say a contractor submits an application which includes a loss and expense claim for £1 million with no backup, nothing. The employer naively fails to issue a payment notice and fails to issue a payless notice. The contractor, being aware of the failure to issue notices, therefore decides to go off to adjudication on a smash and grab and will be successful. The employer will therefore be obliged to pay the amount that is applied for, but they can thereafter go to adjudication on the proper value of the works following Grove Developments. But what you must recognise is if you're going to go on the proper value based on the merits, you're going to be involved in one big adjudication. And he who asserts must prove. So you're going to have all of the information to be able to substantiate the amount properly due. And if you're dealing with liquidated damages and extensions on times and lost expense, that can be extremely onerous. So what we've got to look at is that application to the current situation. Now, the first thing I find all too often is the contract payment mechanism in the contract isn't as clear as it should be. Ideally, you want to have something stated like the valuation date shall be the third Monday in every month. But I've seen the valuation date shall be the date of the site meeting. Who knows when the site meeting is going to be? Or it will be not fixed to a particular thing. It can be very uncertain. So you need to make sure in the first instance that the date for valuation is clearly stated. Now I'm aware, and I've had this situation on more than one occasion, that a contractor and a PQS at the start of the job say, look, I go on holiday in September, there's Christmas, there's these other problems. What I suggest we do is we have a list of dates of the valuation, and then we list out the due date, the final date, and it's all nicely clear and set out. This is often done in subcontracts, where the contractor puts within their subcontract a list of dates for valuation, due dates, and final dates for payment. And that is fine. There is absolutely no problem with that, subject to those dates going all the way up and beyond completion. But what happens if They don't. So let's just give an example that we assume that a job is due to finish in December 2021. But because of the job starting late, because of previous subcontracts, and then variations and everything else, with the fact that the subcontract completion date is very much prolonged and goes well into the next year. What happens? What happens when the valuation dates in the contract have come to an end? Well, it's simple. There aren't any. The only one is the final payment, which is stated in the subcontract. What the parties have done is they've agreed 12, let's say, valuation dates and a final date for payment when the job has been completed or when making good of defects is done. That's what the parties have agreed, and therefore there are no further valuation dates, save for the final payment, after the date stipulated in the schedule. Now, I'm aware, and I've been involved with contractors who have done exactly that. The contract is a standard JCT form. It provides for valuations all the way up to practical completion and valuation dates thereafter every month or every 2 months. And that's what the contract says. And that's obviously greatly to the advantage of the contractor. But the contractor then, trying to be helpful, sets down a whole set of dates and says to the employer, will you agree to these? And the employer says yes, thereby displacing the contract mechanism and reducing the number of valuations. So do be careful. The next thing is that if you are involved in a smash and grab, what can you do? Now, you recognize that you haven't issued a payment notice and you haven't issued a payless notice. It seems that you've got no answer. Well, what you're going to have to do is attack the application. You're going to have to run a case that the application in one way or another is non-compliant. And there are many cases on this. And the basic rule is if the contract stipulates a date that the application must be issued, then it has to be issued by that date. So let's say it says the contractor may issue an application not later than 7 days before the valuation date. Provided it is more than 7 days from the valuation date, it's compliant. But what happens if it's 10 days, 14 days, 21 days, 28 days before the valuation date? Depending upon what's happened in the past, it may well be that whilst it is issued in time, indeed very early, it may not be a compliant payment application. Because what the court says is that the application must be understood by the other party to be exactly that, an application. It was considered that a payment notice had to meet more stringent requirements than an application, but that has now been rejected, and it is clear that both documents have to meet both the same requirements. It must set down properly and detailed the amount due and the grounds and how that amount due is calculated, the basis. And as I've identified, that is in 2 elements. There is the whole makeup to get to the gross sum, and then ultimately the net sum due after previous payments. And you have to be able to work it out. Now, there is no problem including within the notice a cross-reference to another document which achieves that. But you have to meet that requirement. And if you don't, it will be non-compliant. Now, if you issue a payment notice on time and you simply say 0, you're not due anything, unless how you've worked out 0 is detailed, that notice will be non-compliant. Other things you need to look at is what the document is entitled. Now, let's just say that the contractor is looking towards the end of the job and he submits his application, including, let's just say, the 5% retention, or the second moiety retention has been released at just 2.5%. So it is clearly an application because it is not seeking the release of the final retention. But the document is not entitled interim application. It is called final account or draft final account. The case law says that when that's happened, it is not clear that it is an application. And on such basis, it will be non-compliant. So those of you who are contractors, whenever you are submitting an application that may well be also your final account, do state on the top, interim application number 23, for which payment is sought. But please note, this is also our draft final account for your information. In other words, make sure that what you are submitting is an application for payment. Another potential argument, and which I've been involved with again, is the argument of estoppel. This is an argument where a party says you cannot seek payment because I've got a reason in that I understood you were not seeking to rely upon the contract. So let's give an example. The contractor submits an application for payment today, and he meets the employer on site to discuss it in a week's time. And the two of them say, oh yes, we want a bit more information, we want this, we want that, and we're closing on practical completion, so why don't we include within this next valuation the release of retention and everything else? And the contractor says, okay. So the employer says, well, on that basis, look, what I'm going to do is I'm going to delay withholding the payment notice so that we can make sure that we include all this other money and you've justified the amount. And the contractor says, okay. So the contractor has indicated to the employer that they're not going to rely upon the contract and they need to issue a payment notice or a pay less notice in the dates prescribed because they've indicated they're willing to let it slide because of these other factors. Estoppel is used as a shield, not a sword. Therefore, the employer can use it as a shield against the contractor's request on the basis of a smash and grab. He can say, from what you indicated by what you said and how you acted, I understood you were not going to go on a smash and grab for a failure of notices. And in effect, you had agreed to allowing me more time. Provided you can evidence that, then you can potentially protect yourself against a smash and grab. Final thing I want to deal with on notices is an important one, is this one. Let's just say that a contractor submits an application for £1 million and the employer then issues a payment notice showing that in fact the contractor owes the employer money. In other words, it is a negative certificate. It is showing that the contractor owes the employer £1 million. Well, many contracts provide that what is ever stated as the amount due, be it to the contractor or the employer, becomes payable unless there is a pay less notice. In other words, in this situation, the obligation to issue a pay less notice falls upon the contractor. And I've run this adjudication and been successful. So let me just really emphasize this. The contractor submits an application for £1 million. The employer returns with a payment notice saying, no, we assess the amount due is that you owe us £1 million. The contractor does not respond and the final date for payment elapses. The contract says that the contractor and or the employer pays the other party the amount stated as due. And because there has been a payment notice that is compliant, the contractor therefore has to pay the employer £1 million. And as we've identified, there is no defence because there has been no pay less notice. And the contractor can only go to adjudication seeking the £1 million back if they have first paid the £1 million. There is one final thing to discuss, and that is termination. Now, I am doing a course on termination, which I will go in more detail about the two forms of termination. But to cover this particular subject, what I need to tell you is that we have termination under the contract or termination under the common law. And the difference is that termination under the contract is you're using the provisions in the contract to terminate the employment, but not the contract itself. In other words, the contract continues to apply and it sets down what should happen following termination. So, for example, in some JCT forms, what it says is that following termination, the contractor shall not be paid any further sums until the end of the making good defects period. Or it might say something else if it's termination by the contractor. But it's setting out what is it going to happen following termination. Now, under common law, we are not terminating employment. We are terminating the whole contract. In other words, the whole contract disappears. And under termination of common law, it follows a repudiatory breach, a breach that goes to the heart of the contract. It is fundamental. So, if the contract is terminated under the common law, there is no longer a contract. And therefore, there is no longer any payment requirements. There are no payment terms. And as a consequence, the scheme for construction contracts is likely to kick in, or at least as soon as termination occurs, there is another valuation date because the job has come to an end. So what I have found is that employers, when faced with a smash and grab, in seeking to get another valuation in place as soon as possible, have actually terminated. By termination, the contract has come to an end. There is no further works to be done. Under that, the scheme for construction contract says there is then a payment due, and they can then put forward a revised valuation showing, for example, no monies are due. And what we've got in effect is two separate valuations. The smash and grab based upon the earlier valuation prior to termination, and another valuation based upon post-termination. And provided the employer can start that second adjudication before the decision in the first, then they're both likely to run and the contractor is unlikely to be able to stay the second. Okay, an interesting subject. What are the lessons learned? Very simple. Number one, ensure that your contract has a clear payment mechanism, setting out the valuation period, the due date, the final date for payment, the date for issuing a payment notice, the date for issuing a pay less notice, and when an application for payment has to be issued. If you are the paying party, if you disagree with the application, ensure you issue a payment notice and or a pay less notice. That payment notice or pay less notice must set down the amount due, which is in two parts. The first part is to work out the gross amount. The second is to work out the net amount. You have to meet both those requirements. Provided you do that, it is that amount that becomes due and payable. If you fail to issue either a payment notice or a pay less notice, the contractor is entitled to the amount it applied for. Your only defense is to say that the application is submitted by the contractor or subcontractor is non-compliant. And to be non-compliant, it either has to fail to meet the requirements of the contract, doesn't obviously provide the amount properly due in the required format, or was not understood to be a valid application. Do be aware, despite the recent case of Grove, there are still a lot of adjudications on smash and grab. So you have been warned. Equally, for those of you who suddenly now realize that the employer on your project has not done what they should have done, this is a very good tool to get hold of some money and to put tremendous pressure on the contractor to properly value your works. Okay, I hope that's been of use. Julie, are there any questions?
Yes, there are. Someone's asking, can you clarify days or working days? An application made late on a Friday prior to a bank holiday on the following Monday, or Monday on Tuesday in the case of Christmas Day and Boxing Day, i.e. no time to issue a considered payment notice.
Right, very simple. It's what the contract says. If the contract refers to days and doesn't stipulate anything else, it is calendar days. JCT quite often stipulates what is included as a day, and it quite often says, for example, which shall exclude bank holidays. So it is simply what the contract says. But if the contract is completely silent and it simply says days, that's all it is.
Okay. Someone else is asking here, is a letter of intent legally binding?
Okay, obviously slightly off topic. I am going to be doing a course on letters of intent. It's a difficult answer to deal with quickly. So let's start off. A letter of intent is a description of something, and it may have a different meaning depending upon the content of the letter. So letters of intent generally start something like this. Dear sirs, we confirm it is our intention to enter into contract with you. By so doing, it's indicating what it isn't is a contract, because the contract's going to happen in the future and is not happening now. It then proceeds, and it may well say something along the lines of this. We are at present unable to fully agree the scope of works and are still in discussions as to the applicable terms. Again, it's indicating to you that you're not in contract. It then says that we would like you, nevertheless, to commence work on site up to a value of £500,000. But hold on, it's limiting what you can do as to value. And you may well have valued the works at £1 million, so you can't carry them all out. Or indeed, it might be that you valued the works at 500, but it provides a variation, which is also a problem because you can only go up to £500,000. So again, it's indicating you're not in contract. It may say rather than a value that we would like you to carry out the initial works for the first month. So again, it is having a cap on what works can be undertaken to a specific period of a month. Now, if you can only do a works up to the next month, but completion is meant to be in 6 years' time, you can't complete. Sometimes it simply says to carry out the enabling works. What then happens is at the bottom it says something along the lines of this. If we subsequently enter into contract with you, the contract shall have retrospective effect, and all payments under this letter of intent will be deemed to be made under the contract. So it is quite clearly separating what is the letter of intent provisions to what is a contract provision. They're separate, they're different. So again, it's indicating the letter of intent is not a contract. What it then finally says is that if in the outcome we don't place a contract with you, you shall not be able to any claim of loss of profit, loss of this, loss of that, and shall only be entitled to your reasonable amount. So again, it's putting in provisions that are at odds with what will be the eventual contract. So from what you can see there, what I can tell you is it's not what I would call a contract. It is actually what is often referred to as a simple contract. It's actually an area of law called quasi-contract and restitution. And it's actually an area in theory of property law. And the basic situation under a letter of intent is, if it has those nature of terms that I've just suggested, the contractor has a right, and it is enforceable, to recover their reasonable amount for the work that they've undertaken. But there can be no completion date. There can be no liquidated damages. And it is arguable, depending upon the actual letter of intent, whether there is a right to go to adjudication. So, in very simple terms, what is a letter of intent? I'm not sure until I've read it, because it could have a lot of different significances. It could be a contract. It could be not a contract at all, but where the contractor is entitled to a reasonable amount for the works it's undertaken. So do be aware. And do remember, how many of the jobs are you working on where you think you're under a contract, where in fact you are working under the letter of intent? Or how many jobs are you working where the contract has not been signed? And if so, what are you under in those circumstances? Any other questions, Julia?
Okay. That seems to be it for this evening, unless anyone has any last minute thoughts that have occurred to them. So thank you everyone for turning up this evening and listening to our presentation. Next week, we have Wednesday morning, we have Novation with Mohammed Hack. And then on Thursday, we have our construction roundup where Richard is on the panel, along with Mohammed Hack and John Sharp, talking about the latest hot topics in the construction world. If anyone would like a place on any of those, please email us seminars@silverllp.com. And as we said earlier, if there's anything specific you'd like to ask Richard about payment, smash and grab, or indeed letters of intent, then please feel free to email Richard directly, richardsilver@silverllp.com. Okay, just remain to say thank you again, Richard, for your time, and thank you everyone for attending. And we hope to see you all again soon. Take care.
Okay, thanks. Bye-bye.
Thank you.